out of grave concern with the direction of the Senate as an institution and with the choices being made on behalf of the American people. By almost every account, our economy remains severely wounded by the effects of the COVID-19 pandemic. Cases are still rising. In fact, a record was set just in the last couple days. Small businesses are unfortunately closing at an accelerating rate. Foreclosures and evictions are on the rise. Jobless benefits for many have run out, and our state and local governments are running dangerously low on resources to assist teachers, first responders, firefighters, and so many others. But rather than focusing on the immediate needs of the American people and acting to remove the uncertainty being felt by families across this country and in the Commonwealth of Virginia, the Senate is preparing to pursue a partisan exercise to fundamentally alter the composition of our Supreme Court. This comes as we are just a week away from November 3rd, when Americans will go to the polls to cast their ballots in a presidential election. In my state, in the Commonwealth of Virginia, literally almost 2 million Virginians have already voted. President Trump and the Majority Leader are jamming through, at this moment, a divisive nominee to fill Justice Ginsburg's seat on the Supreme Court, Judge Amy Coney Barrett. The Senate has never confirmed a Supreme Court nominee this close to Election Day. The election is in a week. Nearly 60 million people have already voted. And while they eviscerate Senate precedent and rush towards a Supreme Court nomination, they delay passing the kind of critical legislation in terms of additional COVID relief that would help millions of Americans make it through the economic crisis. Think about that. Every day we wait to pass a comprehensive COVID stimulus bill, more people than necessary will get sick, some will die, businesses will be lost, families will lose their homes, and millions of unemployed workers will continue to wonder how they're going to make ends meet. So why has the president rushed Judge Barrett's nomination through the Senate? The president is jamming through this nomination because there is so much on the line with this Supreme Court vacancy. On November 10th, just 1 week after the election, the Supreme Court will hear a case that could invalidate the Affordable Care Act and rip health care coverage away from more than 20 million Americans. 20 million Americans in the middle of a pandemic. The president and my Republican colleagues here in Congress have already tried and tried again and tried again and failed to repeal the Affordable Care Act through Congress. Now they've turned to our nation's Supreme Court in a purely political effort that could devastate our nation's health care system. They've offered no replacement plan that will adequately protect individuals with pre-existing conditions. And millions of Americans will then be set to lose their health care coverage should the ACA be overturned. Now, I've come to this floor many times and acknowledged the ACA is not perfect. There are places where it could be improved. But in the years since its passage, I've heard from countless Virginians that have benefited from the law. Individuals that have gained access to health care coverage for the first time. Cancer patients that can no longer be kicked off their plans or denied coverage. 8 million Americans who've now got COVID, who've got now a pre-existing condition. I've talked to small business owners and entrepreneurs that are now able to get coverage on the individual exchange and consequently start that business that otherwise they couldn't take the risk to start. And so many of Virginia's seniors who've seen their drug costs go down thanks to important reforms in the ACA. Now that in and of itself, being considered by the Supreme Court a week after election, would be more than enough reason to wait and delay and let the American people first have their say. But that's not all that's at stake in future cases before the Supreme Court. This court that will disproportionately be moved out of the mainstream, we're looking at everything from reproductive rights to voting rights to rights for LGBTQ people. All of this hangs in the balance. Given those stakes, the American people have a right to have their voices heard before the confirmation of a new justice. Now, in 2016, Majority Leader Mitch McConnell set a standard when he refused to consider President Obama's Supreme Court nominee 10 months prior to the election. Now, I strongly objected to the Majority Leader's actions in 2016. But he's the Majority Leader, he had the votes, and now that's the precedent by which we should govern this Supreme Court nomination. Because the truth is, we can't have one set of rules for Democratic presidents and a different set of rules for Republican presidents. Our system of checks and balances has held strong and lasting for more than 200 years. And it was simply not meant to bear the brunt of such cynicism and hypocrisy. The Senate should get to the real needs of the American people, a deal that I know Secretary Mnuchin and Speaker Pelosi are quite close to. Let's split the difference and get it done. We should not be considering a Supreme Court nomination before Inauguration Day. Yet the Majority Leader is continuing forward with votes on Judge Barrett's nomination. Judge Barrett's record is clear, and so is my vote. I'm voting no. There's too much at stake. Thank you, Mr. President. With that, I note the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Mr. President.
Senator from Massachusetts.
Thank you, Mr. President. Mr. President, I ask for there to be a vitiation of the quorum call.
Without objection.
Okay, thank you. Thank you, Mr. President. Mr. President, I rise to speak in opposition to the nomination of Amy Coney Barrett to serve as an Associate Justice on the United States Supreme Court. This is no ordinary nomination, and it comes at no ordinary time in the life of our nation. We are in the midst of a global pandemic that has already claimed more than 225,000 American lives. We are a mere 8 days away from a presidential election. Donald Trump announced his nomination of Judge Barrett even before we could fully mourn the death of the great Justice Ruth Bader Ginsburg. And Senate Republicans then rushed this nomination to the Senate floor. In doing so, they violated the rule that their leader, Mitch McConnell, imposed in 2016, which kept Merrick Garland off the Supreme Court after President Obama nominated him in February of that year to fill the vacancy that arose with the death of Justice Antonin Scalia. That rule was clear. That rule was concise. That rule was definitive. The Senate would not consider a nomination to fill a vacancy on the Supreme Court during a presidential election year. Many of my Republican colleagues echoed Leader McConnell's pledge. In fact, my colleague, Senator Lindsey Graham, who chairs the Judiciary Committee, admonished us to use his own words against him if he went back on his promise. Quote, if there's a Republican president in 2016 and a vacancy occurs in the last year of that term, you can say that Lindsey Graham said, let's let the next president, whoever that might be, make that nomination. But the majority has ignored the McConnell rule. and broken their promises, to follow it as they engage in the outright theft of yet another seat on the United States Supreme Court. You can't spell shameful without sham. And that's what Senate Republicans have turned this Supreme Court nomination process into, a sham. What else is unprecedented about the circumstances surrounding the Barrett nomination? Well, in Donald Trump, who made the Barrett nomination, we have a president who has repeatedly refused to commit to a peaceful transition of power should he lose the upcoming election. And in Donald Trump, we have a president who has openly stated that he needs Judge Barrett on the Supreme Court to cast a crucial vote if cases arising out of a disputed election reach the court like Bush versus Gore did after the 2000 presidential election. In Donald Trump, we have a president who has vowed to appoint to the Supreme Court a justice who would vote to overturn Roe versus Wade and take away a woman's reproductive rights and freedom. Even before he was elected in 2016, he pledged, quote, "I will appoint judges that will be pro-life, yes." In Donald Trump, we have a president who has expressly promised that he would only nominate a justice who would vote to get rid of the Affordable Care Act, Obamacare, and coverage for pre-existing conditions. President Trump made that another bright line litmus test for this nomination. In Donald Trump, we have a president who has told us that he needs Judge Barrett on the bench to rule in the Affordable Care Act case. The Supreme Court is scheduled to hear on November 10th, 1 week after the election, a case that will decide the fate of that law and the availability of health insurance for millions of Americans suffering during a pandemic and well afterwards. If Amy Coney Barrett is confirmed to the Supreme Court and votes the way Republicans expect, nearly 3 million people in Massachusetts with pre-existing conditions could face higher costs, fewer benefits, could have trouble finding insurance coverage. Massachusetts was the model for the Affordable Care Act. But if Donald Trump and his Supreme Court nominee have their way, more than 335,000 Bay Staters enrolled through the Medicaid expansion could lose their coverage. And as we experience the highest number of one-day coronavirus deaths since the spring, we have a Republican-led Senate that has been unwilling and unable to work with their party's own president to craft desperately needed legislation that would provide relief to the hundreds of millions of Americans who are suffering during this pandemic. Americans who are out of work through no fault of their own. Americans whose small businesses, the engine of our economy, are struggling or going under. Americans who can't get the medicines, the testing, the protective equipment, or medical care they need. Americans who right now are lacking the access to online learning and the promise of an education. For weeks and weeks, Senate Republicans would not lift a finger to help our workers and our families during this crisis. They would rather our states and our cities go bankrupt, our students go without Wi-Fi, poor students, black, brown, poor children in our country without the internet at home and without the funding to provide it to those kids right now. At the height of the pandemic, there are going to be millions of children who do not have access to the tools they need to be in the third grade, to be in the fifth grade. And even today, our nurses go without the masks which they need. Yet, when it comes to filling a vacancy on the Supreme Court and confirming a far-right justice, these same Republicans made the Senate move with a speed that would make Usain Bolt jealous. Jamming through this nomination in this fashion is unprecedented. It renders this process and this nomination illegitimate, period. If Judge Barrett is confirmed, it will only serve to further erode the stature and the legitimacy of the Supreme Court in the eyes of the American people. Now, everything to which I've just pointed, the pandemic, the election, the corruption, are just the place settings. It's the table onto which Donald Trump has served up the nomination of Amy Coney Barrett. Judge Barrett is a proud originalist and textualist in the mold of her mentor, the late Justice Antonin Scalia, one of the staunchest and most arch conservatives ever to serve on the United States Supreme Court. And as Judge Barrett put it at her own confirmation hearing, Justice Scalia's judicial philosophy is mine too. As Judge Barrett described so-called originalism, it means she's supposed to interpret the Constitution's text and understand it to have the meaning it had when the Constitution was ratified. But interpreting the Constitution in that manner has been used over and over to deny rights to women, to communities of color, and to the LGBTQ individuals, members of our society who had no rights when the Constitution was ratified. Originalism is racist. Originalism is sexist. Originalism is homophobic. For originalists like Judge Barrett, LGBT stands for let's go back in time, a time when you couldn't marry who you love, when you couldn't serve in the military if you were trans, a time when rights were not extended to gay, lesbian, bisexual, transgender, queer, questioning, or intersex individuals. Originalism is just a fancy word for discrimination. It has become a hazy smokescreen for judicial activism by so-called conservatives to achieve from the bench what they cannot accomplish through the ballot box. And an elected Congress, and as a result, they roll back individual rights through judicial decisions. The activists, originalists, judges on the Supreme Court, and lawyers in its legal community are poised to repeal the Affordable Care Act, deny reproductive freedom, and repeal same-sex marriage. They will welcome a Justice Barrett and a 6-3 conservative majority with open arms. So we know a lot about Judge Barrett's judicial philosophy of originalism. What about her application of it and her views? Well, in early 2017, 4 months before Donald Trump nominated her to serve on the U.S. Court of Appeals for the Seventh Circuit, she wrote a law review article in which she criticized Chief Justice John Roberts' majority opinion in NFIB versus Sebelius, which upheld the Affordable Care Act. She made clear she didn't think much of Justice Roberts' opinion, arguing that he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. We know from another law review article that Judge Barrett, like many originalists, does not give precedence the respect that it deserves. In 2013, she wrote that because a justice's duty is to the Constitution, there is, quote, more legitimacy in enforcing her best understanding of the Constitution rather than a precedent she thinks clearly is in conflict with it. In other words, she believes that her own interpretation of the Constitution is more important and more legitimate than precedent such as Roe versus Wade. We know from her dissenting opinion in Cantor versus Barr that she believes a felony conviction shouldn't necessarily result in losing the right to own a gun, but she's okay with felony convictions taking away the right to vote. Should make it easier for a felon to own a gun than to vote. That's the kind of result that Judge Barrett's originalism gets us into. So, on many of these issues, Amy Coney Barrett has shown us that she couldn't be further in spirit from Ruth Bader Ginsburg, the late great justice whose seat on the nation's highest court that she will fill. While Justice Ginsburg always had us looking forward, Amy Coney Barrett and her originalism will always have us looking backwards, and backwards is precisely the direction in which this nation should not be going. So what we know from Amy Coney Barrett's own words is very troubling. Yet then, at her confirmation hearing, we learned that there are many basic, fundamental legal issues on which she would not say a word, and she would keep her views hidden. At her confirmation hearing, Justice Barrett declined to answer questions about such important propositions as whether it's unlawful to engage in voter intimidation. Spoiler alert, it is. On questions whether the president can delay a presidential election. Newsflash, he can't. Questions about whether presidents should commit to a peaceful transition of power. Listen up, they should. Questions about whether Obergefell versus Hodges, the landmark Supreme Court decision recognizing the right to gay marriage and making marriage equality the law of the land, was correctly decided. No doubt about it, it was. Questions about whether the non-discrimination provisions of the Affordable Care Act protect LGBTQ people from discriminatory treatment in healthcare. Of course they do. Questions about whether Roe versus Wade was correctly decided and is a super precedent. It was and it is. Questions about whether Medicare is constitutional. Of course it is. Questions about whether climate change is real and whether human beings cause it. It is, and we do. On these and so many important issues and questions, Judge Barrett refused to give the obvious and indisputably correct answers. But based on her judicial philosophy, her writings, and her record, I have little doubt where she really stands. And that is the same corner with right-wing reactionary jurists who are far outside the mainstream of American jurisprudence. And finally, there is another question that Judge Barrett would not answer: whether, if confirmed, she will recuse herself from the Affordable Care Act case and any election cases that reach the Supreme Court. There's a federal statute that governs the recusal decision. It requires recusal in situations where a judge's impartiality might reasonably be questioned. President Trump himself put Judge Barrett's impartiality at issue when he confessed that he needed Judge Barrett on the Supreme Court to decide any election disputes. He did it when he said he'd only appoint a justice that would vote to overturn the health care law. And after reviewing Judge Barrett's record and listening to her testimony before the Judiciary Committee, it's becoming clear that we have a binary choice. We can have the Affordable Care Act, or we can have Amy Coney Barrett on the Supreme Court. We can have the ACA, or we can have ACB, but we can't have both. Judge Barrett needs to do the right thing and recuse herself. I will conclude by noting the irony that Ruth Bader Ginsburg and Mitch McConnell were both on the same page as to this nomination. In 2016, Senator McConnell gave us his promise that the Senate would not fill a vacancy on the Supreme Court in a presidential election year. And after she passed, we learned that it was Justice Ginsburg's dying wish that she not be replaced until a new president is installed. So let us hold Mitch McConnell and Lindsey Graham to their words and honor Justice Ginsburg's fervent wish. No confirmation before inauguration. But if Republicans succeed here today in their effort to confirm yet another conservative Supreme Court justice just days before the presidential election, as soon as the Democrats take back control of the Senate in January, we must abolish the filibuster and expand the Supreme Court. We cannot allow such corrupt partisanship to take precedence over justice and liberty in our country. I will vote against the confirmation of Judge Amy Coney Barrett to the United States Supreme Court and urge my colleagues, all of my colleagues, to do the same. Mr. President, I yield back.
The first number is 4. 4. That's how many Supreme Court vacancies have arisen after July 1st and before Election Day in a presidential election year. Only 4 times in the history of this country has a Supreme Court vacancy arisen within 4 months of a presidential election. The next number I think is very important to remember, and that number is 0. 0. That's how many times these vacancies were filled. In fact, similar to this vacancy, President Lincoln had a Senate majority when a vacancy arose just weeks before Election Day in 1864. And what did he do? He chose to wait. President Lincoln thought nominating a justice so close to an election would delegitimize our institutions and harm the republic that he was fighting so hard to preserve. That's the precedent that President Trump and Senate Republicans have disregarded as they quickly plotted to fill this seat just hours, if not minutes, after Justice Ginsburg's passing. In addition to breaking with this historical precedent, Republicans are also jamming through their nomination in the middle of a pandemic that is gripping our country. Instead of prioritizing Michigan first responders, small businesses, workers, teachers, and families and healthcare professionals that are still suffering through the effects of the coronavirus pandemic, Senate Republicans and the president are instead laser focused on jamming through a Supreme Court nominee for a lifetime appointment. This is more than just political gamesmanship. This nominee will significantly impact the lives of Michiganders and folks all across our country. We know that the Supreme Court is set to shortly consider a case that has far-reaching ramifications for people's health care. The Trump administration is arguing in court that the Affordable Care Act should be overturned in a case that will come before the Supreme Court in November, just 7 days after Election Day. If the Trump administration gets its way in this lawsuit, we could go back to the days when insurance companies once again call the shots on people's health care. Over 4 million Michiganders with pre-existing health care conditions could be denied coverage. Seniors could be charged more for prescription drugs. Lifetime and annual limits on coverage could make costs unaffordable, and as a result, force families into bankruptcy. Before the passage of the Affordable Care Act, medical debt was the #1 reason for personal bankruptcy. People faced financial devastation simply because they got sick. Women could again be charged more for being a woman because a potential pregnancy is a pre-existing condition. We have come way too far to be turning the clock backwards. For the Trump administration to be pushing this lawsuit is reckless and dangerous, especially during the worst public health and economic crisis in generations. But that's not all that's at stake. A woman's right to make her own health care decisions and reproductive freedom is at stake. Workers' rights against corporate special interest are at stake. Environmental justice is at stake. Access to the ballot box is at stake. Attempts to end the corrosive effect of money in campaigns and elections is at stake. And LGBTQ rights are at stake. Those are just some of the many issues that a Supreme Court justice with a lifetime appointment will be ruling on for decades to come. Judge Amy Coney Barrett's nomination has extremely far-reaching consequences. We are just a few days from Election Day. Already over 2 million Michiganders have voted, and many more are voting as I speak here today. With all that's at stake, Michiganders deserve a say in who nominates and confirms the next justice to our nation's highest court. And the fact that Michiganders are being denied this opportunity is simply unacceptable. Therefore, I cannot support this nomination process. It should wait until a new president and Senate take office following an election to take place in only a few days. So for this reason and many others, I will not be voting for Judge Barrett's confirmation and will cast a no vote. So Mr. President, here we are. Instead of bringing folks together to find common ground on coronavirus relief, our country is being forced to go through a divisive Supreme Court nomination process. It simply did not have to be this way. I continue to stand ready to roll up my sleeves and put together a comprehensive, bipartisan, and meaningful COVID relief package. Ask any Michigander what they're worried about today, and you're going to get the same answers from them. They're worried about being able to put food on the table or a roof over their head. They're worried about getting or keeping a job to support their families. They're worried about catching a virus that has killed over 7,000 of their fellow Michiganders and over 220,000 people all across our nation. They are worried if they survive a COVID infection, it will compromise their health for the rest of their lives. They will have a pre-existing condition. So I ask, why isn't this pandemic the Senate's top priority right now? When we passed the CARES Act, we came together. We put politics aside and passed a real comprehensive package that helped keep millions of people stay afloat. We need to summon that spirit again. Michiganders are counting on us. Americans across this country are counting on us. Mr. President, I implore my colleagues to drop what we are doing and let's come together and pass a meaningful bipartisan COVID relief package, and let's get that done now. Mr. President, I yield.
Mr. President.
The senator from New Mexico.
Mr. President, I rise today as more than 220,000 Americans are dead from the coronavirus. There are more than 4 million fewer jobs than when Donald Trump took office. We are still squarely in the middle of this pandemic and an economic crisis the likes of which we have not seen since the Great Depression. In recent weeks, cases of the coronavirus have risen dramatically in my home state of New Mexico and frankly across the entire country. Everyone is rightly worried about whether our schools and our child care centers and our small businesses can acquire the resources and the equipment they need to reopen safely. We still don't have enough resources or even a national plan for testing and contact tracing, much less for treatments and the eventual nationwide distribution of a FDA-approved vaccine that would allow us to finally get a handle on this virus. And if we don't pass real economic relief in the coming weeks, many families in New Mexico will face desperate choices between paying their bills, keeping a roof over their heads, or putting food on the table. And yet, here we are, using valuable time on a Supreme Court confirmation process that should have never been taken up before the election. Senate Republicans say they aren't going to negotiate another coronavirus relief package. They say it's more important to ram a Supreme Court nominee through a broken and nakedly political process than it is to help the people that we were all elected to serve. Clearly, nothing, not even the lives and livelihoods of the American people, will get in the way of their power grab designed to reward their biggest donors and the most extreme interests. Well, let me say this clearly. I disagree. There is still so much we need to do to stop the spread of the coronavirus and support families, workers, businesses who are struggling and rebuild our communities. Let's move to that urgent action. But with Senate Republicans refusing to do that, let's discuss in real terms what they're doing instead. Considering and confirming Supreme Court nominees is one of a senator's most solemn duties under the Constitution. We are supposed to take it seriously, deliberately. But Senate Republicans have thrown out the rule book. It started when with nearly a full year remaining in President Obama's final term, Senate Republicans refused to even hold hearings on Merrick Garland, the nominee to replace the late Justice Antonin Scalia. Then they dismantled the rules that had ensured that both parties would have a seat at the table on Supreme Court nominations. And then they bull rushed the vetting process for Justice Kavanaugh's lifetime appointment to the court, despite multiple credible allegations of sexual misconduct. After all of that, I suppose it should have come as no real surprise that Majority Leader McConnell waited less than an hour after the announcement of Justice Ruth Bader Ginsburg's death to say that he was going to push the envelope even further. So here we are. Leader McConnell and Republicans are now forcing the Senate to rush through another partisan Supreme Court confirmation battle, mere weeks, now mere days, before Election Day. They are shamelessly discarding their own precedents, breaking their own rules, abandoning their own words. And they are trampling on the legacy of Justice Ruth Bader Ginsburg. Before her death, Justice Ginsburg told her granddaughter that her most fervent wish was that her seat wouldn't be filled until after the next president is inaugurated. Justice Ginsburg served on our nation's highest court for nearly 3 decades and worked for decades before that to move our country's laws towards greater equality. She understood that the American people must trust that the Supreme Court justices are acting above the partisan politics of the moment. The next presidential election is now less than 2 weeks away. Millions of Americans have already voted for their next president and their next senators. I believe that these Americans deserve a voice in this process. In the words of Majority Leader McConnell himself, as reported in the Washington Post on February 18th, 2016, quote, "Given that we are in the midst of a presidential election process, the American people should seize the opportunity to weigh in on whom they trust to nominate the next person for a lifetime appointment to the Supreme Court." The Senate should follow that precedent and should allow voters to decide who should fill this Supreme Court seat. So what has changed for Majority Leader McConnell? Well, in the last decade, the court has made razor-thin 5-4 rulings on women's rights, on LGBTQ rights, on workers' rights, immigration, voting rights, civil rights, climate change, and much else. Now, my Republican colleagues will say that these decisions were made by activist judges and that all they want are judges who will call balls and strikes. But what they really want are judges who will make those calls consistently biased towards wealth and power rather than towards people. For all the talk of activist judges, it is my Republican colleagues who are right now attempting to add one whopper of an activist to the Supreme Court. Next month, the Supreme Court will take up President Trump's case to eliminate the Affordable Care Act in its entirety. That's right. In the middle of this pandemic that has now killed more than 220,000 Americans and infected millions more, the Supreme Court is taking up a case that could eliminate health care coverage for millions of Americans. Now, Judge Barrett refused to answer questions about the Affordable Care Act during her confirmation hearings last week. But her views on the health care law are clear, and they are exposed in the public record. Judge Barrett has repeatedly and publicly criticized the Affordable Care Act. She has said that the Supreme Court should have already invalidated it. If Senate Republicans have their way, she will have the opportunity to do just that. And what would it mean if the Supreme Court overturns the Affordable Care Act? It means bringing back discrimination, higher costs, even outright denial of coverage for more than 800,000 New Mexicans living with pre-existing conditions like heart disease, diabetes, cancer, and now COVID-19. I am particularly worried about what this would mean for the people in Indian country, who have been disproportionately impacted by this pandemic. In New Mexico, tribal nations have experienced heartbreaking losses, and healthcare resources in the tribal communities have been incredibly strained. I have lost friends and mentors in Indian country, and I know others who are still struggling to recover from this virus. I can't even imagine how much worse this situation could become if the health coverage provided by the Affordable Care Act were ripped away. When we passed the Affordable Care Act, I fought hard to include a permanent reauthorization of the entire Indian Health Care Improvement Act, which supports the care provided to Native Americans through the Indian Health Service. An estimated 290,000 American Indians and Alaska Natives also gained health coverage through the Affordable Care Act's Medicaid expansion. All of that is at risk if the Supreme Court overturns the Affordable Care Act. If Judge Barrett is confirmed, she will also attack other important Supreme Court precedents, from Roe v. Wade to the recent marriage equality decisions. Now, she dodged questions on these issues during her hearing, but her academic and judicial record make clear Judge Barrett's extreme beliefs and philosophy. In her hearing last week, Judge Barrett also refused to take a firm view on climate change. Now, we have major wildfires burning right now in northern New Mexico in October, Colorado, California, seeing much of the same. We don't have time to debate the undisputed facts and realities of climate change, especially with a judge that would strip us of the tools needed to address it. Tellingly, Judge Barrett also refused to agree to recuse herself from any decisions related to the upcoming presidential election. Now, given that President Trump considers Judge Barrett his justice, this creates a dangerous conflict of interest. It's also a very real threat to the foundation of the Supreme Court as an equal and independent branch of government. Meanwhile, instead of attempting to tear down our democracy, the House of Representatives has passed multiple coronavirus relief bills over the last 6 months that would help workers and families, and they are already willing and able to negotiate with the president, to negotiate with Leader McConnell, to come to some sort of bipartisan agreement. But Majority Leader McConnell and Senate Republicans have walked away from the negotiating table, leaving us with nothing but false promises, sham bills to provide themselves a little political cover before an election. We all know the real story here. Behind closed doors, Majority Leader McConnell is actively discouraging negotiations on a bipartisan relief bill. Let me say this to Majority Leader McConnell and all of my Republican colleagues. If voters re-elect your Republican majority and President Trump, there will be plenty of time to move forward with a real and legitimate Supreme Court confirmation process. Right now, we should be focusing all of our energy on delivering the aid that Americans so desperately need. Protecting the health and the economic well-being of Americans, that is what our country expects of us. That is our duty. Let's get to it. Mr. President, I yield the floor.